The new law does not introduce significant changes to the principles behind the current housing law in relation to the control of the occupation and ownership of property in the island. The law effectively brings these forward and incorporates today's housing policy within its body. During this short talk, I shall review the regulation of property transactions involving licensed, entitled and registered status. I shall consider the specific conditions which will apply to transactions involving companies and other legal entities. I shall also, within the context of the main subject, look at the relevance of the Register of Housing, registration cards, and the sanctions available to the Minister under the law. So, kicking off with licence status, the Minister, in granting licence status, may attach such conditions as he shall consider appropriate. The terms of the licence may restrict the individual to occupying rented accommodation only. This could apply, for example, in a situation where the individual's skills were deemed to be in the interest of the community for a limited period only, such as the fulfilment of a short-term contract. The licence may be restricted to a period of less than 10 years. Under Article 19 of the new law, a licensed person can only acquire land relating to a unit of dwelling accommodation, which must be occupied as his sole or principal place of residence in Jersey. The licensed individual, and if applicable, his jointly owning spouse or civil partner, must sell his dwelling accommodation to a qualified purchaser if his licence expires before he attains entitled status. The transitional provisions of the new law will allow an existing J category qualified individual to convey his residential unit into his own name or jointly into the names of that individual and his spouse or civil partner. Under the new law, all existing J category housing consents will be deemed to contain a condition to the effect that if the relevant property is retained in corporate ownership, it must be transferred out of that company as soon as the J category individual qualifies for entitled status. Register of Housing. Article 16 of the new law requires that all units of residential accommodation must be listed in a register which is to be accessible to everyone online. The register will list each unit as either qualified or registered. Only entitled or licensed individuals will be allowed to occupy qualified residential property, whereas all categories of Jersey residents will be able to occupy registered units. The register will note whether a property has a condition or concession attached to it. The details of any condition or concession will be restricted and not available to the public if that condition or concession confers private information. All existing unqualified properties, that is lodging houses, and certain other property to which I shall refer later, will be classified as registered property, which may be occupied by everyone, whether they be entitled, licensed, entitled for work only, or registered. Registered status. The occupiers of registered property will have the benefit of rights as tenants who will be able to take paper leases for a term not exceeding 9 years, and their landlord will have to comply with the terms of the new residential tenancy Jersey law when this comes into force later this year. In addition to being able to occupy registered property, registered status residents will be able to share living accommodation in qualified property with the consent of an entitled or licensed resident, occupying the whole or at least a substantial part of that property. Registration cards. Any entitled or licensed resident holding an appropriate and valid registration card will be entitled to buy or rent property or land without the consent of the Minister. Individuals who hold registration cards which do not record permanent entitled status will require the Population Office to validate their cards, in the same way as that office under the present housing law determines the continued residence of those who do not enjoy inalienable housing rights. Prospective purchasers and tenants will be required to surrender their registration cards for examination by their lawyers or landlords. All parties transacting will be responsible for ensuring the existence of a valid, appropriate registration card. Specific provisions for companies and legal persons. Article 20 of the new law requires that a legal person, that is, any entity other than an individual, such as a company, a charity, or a church, must acquire the consent of the minister before entering into a specified contract, which is a contract relating to the sale or transfer of land, or a lease of any land, whether excuse me, an oral or a written lease or a registered contract lease. This restriction does not include a contract of division of inherited or demised immovable property, a partage of property, or a lease for a property not including dwelling accommodation. No ministerial consent is required in relation to these transactions. Public utility companies are not required to apply for ministerial consent in relation to transactions involving the leasing of land to accommodate any apparatus necessary for the supply or control of gas, electricity, water, or telecommunications. Companies and other legal entities will still be required, therefore, to obtain consent before transacting. No consent will be necessary, however, where a company or other legal entity enters into a contract lease, that is, a lease for more than 9 years of non-residential property. Current housing policy dictates that a company should not own more than a single residential unit. A company may acquire a property and develop it, but must convey out any freestanding units in that development to appropriately qualified individuals, pursuant to the regulations of the present housing law. This policy is included within the restrictions covered by Article 20 of the law. Sanctions or penalties under the law. By reference to Article 17 of the new law, the Minister may apply to the Court to seek a declaration that a period of time spent in an illegal occupation will not count towards the period of continuous residence required to gain entitled status. The current housing law includes a provision which enables illegal transactions to be declared void. The provision is never used and has not been included in the terms of the new law in order to ensure that innocent parties to a transaction are not penalised. The legislature has instead opted to include strong and clear penalties. Article 21 provides that anyone who is in contravention of the provisions or conditions of the law will commit an offence and be liable to an unlimited fine. Ministerial consideration. Articles 15 and 20 of the law require the Minister to give consideration to any matters affecting the supply and demand of housing when determining an application to change the housing category of a residential unit or to vary any conditions attaching to such unit, or when considering an application on the part of a company or other legal entity to enter into a specific transaction. The Minister is required to make adequate provision of residential property for entitled persons, so that the interests of entitled persons are given priority. Although it is likely that preference will be given to applications to build units of qualified accommodation, if the prevailing economic conditions and housing availability result in registered housing being in short supply, the Minister might be persuaded to allow a change of categorisation from qualified property to registered property. Registered property. certain property which under the housing law is presently available for occupation by unqualified individuals will not be subject to ministerial control under the new law. This includes the following property, which in the register will be subject to special conditions or otherwise classified as registered property. Now, it's something of a shopping list, but all the dates on the slide are indicative of moments in time when the housing law or perceived loopholes in the housing law were blocked off. These are being carried forward. So, property inherited on or after the 10th of March 2006 may be occupied by the person who inherited it, provided that that individual must occupy the unit of dwelling accommodation as his sole or principal place of residence or as holiday accommodation. The property shall not otherwise be occupied other than by entitled or licensed individuals where such property was inherited prior to the 10th of March 2006. It may be occupied as registered property. Property acquired before the 4th of April 1949, when the housing law came into effect, shall be listed as registered property, as will property inherited by a body corporate prior to the 10th of June 1993. Property acquired by an individual or body corporate before the 10th of June 1993, where that property was the subject of a dégrèvement or disgumberment. That is the process whereby the land belonging to an insolvent owner is cleared of registered charges. And land in the ownership of a body corporate acquired by that company before the 4th of April 1949, where that property existed on the 28th of July 1998, or was under construction on that date, or constructed under a planning consent granted before that date. In the event of the owner of property acquired in any one of the above ways selling or transferring that property, it will become qualified property. The new law has had a fairly easy passage through the legislative process. It was approved unanimously by the States Assembly, the only animated discussion seemingly relating to a certain concern as to which minister should administer the law, or as Senator Maclean put it, which fox should have the keys to the henhouse.